Thanks, Senator Rono.
Thank you.
Senator Whitehouse.
Thanks very much, Chairman, and thanks to all of the witnesses for being here. I'd like to take my time as we close out this hearing to interrelate the problem that we're talking about today with the related problem of right-wing capture of the United States Supreme Court, an enterprise which the Center for Media and Democracy says has cost $570 million. Pretty darn big number to spend if you don't expect results. So sure enough, it seems that they got results for their expenditure, and I contend that one of those results was the Shelby County decision. And I'd like to focus a little bit on the fact-finding piece of that decision. I think we all know, anybody who's a lawyer in the room knows that as a general proposition in the American system of justice, the facts get found at the district court level. That's where the adversarial process can be brought to bear on potentially false facts. That's where the parties who are charged in our system to bring in facts and present to the judge have the opportunity to do that. That's where appellate scrutiny of errant fact-finding can take place. And the result of all of that is quite a robust and honest fact-finding process in the United States system of justice. Those safeguards fall completely apart when at the very end of the day, after the arguments, after the briefs, at the very highest court level in the Supreme Court, the justices in the majority invent new facts. Just as a procedural matter, they're not supposed to do that. And it's particularly frustrating and concerning when the facts they find are false ones. In Shelby County, the majority opinion determined that things had changed dramatically on racial gerrymandering, voter suppression, and other issues in the pre-clearance states, the ones that were under the rule that they had to submit new rules for clearance to a court or to the Department of Justice before they could proceed, and made the decision that this part of the Voting Rights Act was no longer justified by current needs. And that question of how much things had changed and what the current needs were had no foundation in the court or the legislative record. There were lower court determinations that pointed out significant voter suppression efforts in Shelby County itself and in Alabama more generally. What the court did was to take that statute and look at it as a facial challenge to the statute, which got it by having to reckon with the judicial record that had been established of persistent voter suppression efforts. So they just shot by the record that existed. That was supplemented by a congressional record from the reauthorization of the Voting Rights Act, which was very robust and represented hours of hearings, enormous amounts of documentary work, testimony from experts and advocates and people in the pre-clearance states. And the congressional record was very clear that reauthorization was justified, that some of the techniques of voter suppression had changed, but even though some of the techniques had changed, new techniques had emerged, and therefore the pre-clearance process should be renewed, and that was accomplished on a bipartisan basis, with a massive bipartisan vote in both houses. And what the court did was simply pay no attention to the congressional record, to basically write it off. Well, folks, we're an independent branch of the government. We've got every bit the right of the Supreme Court to decide what the facts are in a matter. We're actually the place where that decision better belongs, because if we get it wrong, voters can have a say about that. Whereas if the Supreme Court gets it wrong, we're stuck with zombie decisions based on false facts that just persist and persist and persist unless and until the Supreme Court is willing to clean up its own errors. but it's hardly likely that they will persist in cleaning up their own errors when they went ahead and made the errors in the first place. So there's a test of whether or not this was accurate, and the test was real life. And in real life, as soon as the preclearance was lifted, there came an avalanche from preclearance state after preclearance state, over 100 pieces of legislation, sometimes targeting minority voters with what one court called surgical precision to affect the election outcomes to the benefit of Republicans in those states. That is the background that bothers me. My time is expired on this, but I did want to make that point, and I thank the chairman for holding the hearing.